Hey everybody, it's Adam Tracy, and in light of the decision on June 9th concerning DAO and whether or not an unincorporated DAO can avail itself of the alleged legal liabilities of DAO, which I'll get into, the court, United States District Federal Court, interpreting California law, said that the DAO itself is akin to a general partnership. And I've talked about that before. And the problem with the general partnership is that all of the members of the partnership can be held liable for the acts of the DAO. And you've seen that in a civil case related to UKI, where in another intermediary order, the judge ruled that each member of the DAO could be individually liable. So like for joint and severally liable. So for instance, if you had somebody put in 10 million, and then you had somebody put in 1,000, those two individuals, irrespective of the relative disparity between how much they invested in the DAO, could both be held similarly liable for all the debt and obligation of that DAO, right? So it's a serious thing. And despite what you read, a lot of and mostly in crypto media, it's all wrong. Like none of this is really legal precedent. It's persuasive. And as those cases go on, especially the DAO with the CFTC, it was a default judgment. It's just persuasive. It's not law, right? But it can be used down the road, and eventually I think it'll go that way. So obviously, the objective is to find a legal entity DAO. And I've talked about the Wyoming DAO a lot because as an LLC, it will protect the individual DAO members from the liabilities of the DAO. And for $100, it's insanely easy to do, and you have no reason not to do it, right? There's no reason not to do it. And even from the crypto anarchist, eschew all formality, it's insane. And for the promoters, the people that are starting it, I think you have a responsibility to future DAO members to do that, to insulate them from liability related to the DAO down the road should it come, right? And the reality is, overwhelmingly, these decentralized organizations are running some kind of DAX or, like in the case of UKI, like a leveraged trading platform, which is a commodity interest, which falls under the guidance of the CFTC and requires registration and all this kind of stuff. So the question is, where do you go if you want to do it outside the United States? Because in the United States, you just have Wyoming. And a lot of people come to me and go, well, where should we set up a DAO? But we don't want nothing to do with the United States, which is fair. So, you've had nascent attempts at creating DAOs like in Germany. Switzerland doesn't have a dedicated DAO, but they have some guidance on how to use an AG to sort of create a DAO, so on and so forth. But there's no pure DAO form. One country that really doesn't regulate crypto, but does have a DAO structure is the Marshall Islands. And you see more people going to the Marshall Islands, even especially in the Forex context, because it is unregulated, right? So when Forex was shut down in St. Vincent, which is unregulated, a lot of people went to Marshall Islands. And the Marshall Islands actually has a DAO entity, a DAO structure. And there's two. There's a non-for-profit entity, right, which is registered, offers, limited liability to its members, officers, and directors. But as a non-for-profit, none of the profits from the DAO can be distributed to the members, the officers, and directors. So kind of, it has to be a very altruistic meaning or purpose to create a DAO of that nature in Marshall Islands. Alternatively, after they created the non-for-profit DAO structure, they created a for-profit DAO structure. And it's really just like a US LLC. And the Marshall Islands is a hybrid of US law and English common law, right? So they acknowledge what LLCs are, but then there's still elements of the common law in there. And the DAO, for-profit DAO formation in Marshall Islands will allow for profit distributions, but it's subject to tax, right? It's subject to a 3% tax, which, it's a relatively small cost of doing business, all things considered. And when you're looking at the, legal landscape, despite the relatively unevolved financial ecosystem in Marshall Islands, it's actually not a terrible choice. And lack of options obviously makes for clear choices, and there are a lack of options. So you look at it and you go, well, it's cheap. It only takes about 2 weeks to set up. It gives everybody legal liability. It operates like a true DAO by smart contract, by decentralized protocol, so on and so forth. There's optically maybe some aversion because it is in the Marshall Islands, but at the end of the day, what other options do you really have if you're going to go outside the United States? And the inability to attach legal liability to the members will, be omnipresent throughout the globe. So if you have members that are in Germany, members that are in the UK, and there's any sort of legal liability, one, any sort of lawsuit would naturally have to be brought in the Marshall Islands or the United States just because of the way we interpret our laws. But two, the limitation on liability would be honored in places like the United States. So it's not a terrible thing in the sense that it operates the right way and it provides you with the legal liability. And Marshall Islands really doesn't regulate crypto in any real form, especially the exchange of crypto. So, obviously there's AML considerations and all that, but, if you wanted to run an exchange or a levered options exchange, anything like that, you wouldn't really need an additional license. And conceptually, the whole point and the argument, which is another video unto itself about why a DAO wouldn't be subject to commodities or securities regulation, which is mostly due to the lack of centralized management, it's really not an issue there. So it's something to consider, right? Because right now, there's nowhere else to go, really, outside the United States. And you can always structure DAOs like in BVI, but they're just private limited companies, and you have to just kind of rig up how you do your memorandum and articles of association. So it's worth it's worth investigation, right? And as more countries create these entities, you can always move, right? There's always the ability to re-domicile because countries and states compete for incorporation business from each other, so they make it easy to re-domicile. So if somewhere down the line, a more optically pleasing or better regulatory environment creates a DAO structure, you can always move that Marshall Islands DAO to somewhere else. So that's my take on the Marshall Islands DAO structure. Obviously, hit me up with any questions, Adam at adamtracy.io, and I'll talk to you next time. Cheers.